State, are you ready?
Yes, sir, you're
Defense, are you ready? Defense, are you ready?
ready, Your Honor.
Okay. Madam Bailiff, would you please bring in the jury? Everyone, please stand. You can be seated. Jefferson County Court at law number 2 is now in session. The court is in session and calls numbers M331-242 and calls number M331-244. Both cases are styled of state of Texas versus Matthew Joseph Bailey. Let the record reflect that Mr. Bailey is present in court with his attorney. And let the record reflect that the state is also present with assistant district attorneys. Let the record also reflect that the jury is now present and seated in the courtroom. State, are you ready?
Yes, sir, you're
Defense, are you ready?
ready. It's ready, Your Honor.
Okay. At this time, ladies and gentlemen of the jury, I will read to you the court charges. In cause number M331-242, case of style of state of Texas versus Matthew Joseph Bailey. The defendant, Matthew Joseph Bailey, stands charged by information with the offense of being intoxicated while driving or operating a motor vehicle in a public place. The offense is alleged to have occurred on or about the 29th day of August of 2021 in Jefferson County, Texas. The defendant has entered a plea of not guilty. Our law provides that a person commits an offense if the person is intoxicated while driving or operating a motor vehicle in a public place. A person is deemed to be intoxicated within the meaning of the law when such person does not have the normal use of physical or mental faculties by reason of introduction of alcohol, a controlled substance, a drug, a dangerous drug, or a combination of at least two of these substances, or any substance into the body, or by having an alcohol concentration level of 0.08 or more. A public place means any place to which the public or a substantial group of the public has access and includes, but is not limited to, streets, highways, and the common areas of schools, hospitals, apartment houses, office buildings, transportation facilities, and shops. Now, if you find from the evidence beyond a reasonable doubt that on or about the 29th day of August of 2021 in Jefferson County, Texas, the defendant Matthew Joseph Bailey was intoxicated, and while so intoxicated, did drive or operate a motor vehicle in a public place in Jefferson County, Texas, then you will find the defendant guilty. Unless you so find beyond a reasonable doubt, or if you have reasonable doubt thereof, you will find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, indicted for, or otherwise charged with the offense gives rise to no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in her presence. If any question develops during your deliberation, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of attorneys do not constitute testimony, and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits submitted into evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced in the evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror, nor consider it yourself in arriving at a verdict. Our law provides that a defendant may testify on their own behalf if he elects to do so. This, however, is a privilege accorded a defendant. And in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take into consideration for any purpose whatsoever as a circumstance against the defendant. You are the exclusive judges of the facts proved, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done. Now, the verdict page in cause number M331242 is as follows. If your verdict is, we the jury find the defendant not guilty as charged in the information of driving while intoxicated, then your foreperson will sign the top line. If your verdict is, we the jury find the defendant guilty as charged in the information of driving while intoxicated, then your foreperson will sign on the bottom line. Now I will read to you the second charge. Okay, the second charge is in cause number M331244. And it reads as follows. Members of the jury, the defendant, Matthew Joseph Bailey, stands charged by information with the offense of unlawfully carrying a weapon, engaged in criminal activity on or about his person, alleged to have been committed in Jefferson County, Texas, on or about the 29th day of August of 2021. The defendant has entered a plea of not guilty. Our law provides that a person commits an offense if the person intentionally or knowingly carries on or about his person a handgun in a motor vehicle or watercraft that is owned by the person or under the person's control at any time in which the person is engaged in criminal activity other than a Class C misdemeanor that is a violation of a law or ordinance regulating traffic or boating. A person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly with knowledge with respect to a result of his conduct when he is aware of that his conduct is reasonably certain to cause the result. Now, if you find from the evidence beyond a reasonable doubt that on or about the 29th day of August of 2021 in Jefferson County, Texas, the defendant, Matthew Joseph Bailey, did intentionally or knowingly carry on or about his person a handgun in a motor vehicle that was then and there under defendant's control, and the defendant was then and there engaged in criminal activity, to wit, driving while intoxicated, an offense other than a Class C misdemeanor that is a violation of law or ordinance regulating traffic or boating, then you will find the defendant guilty as charged. Unless you find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. And again, this charge have general instructions, and they are as follow. All persons are presumed to be innocent, and no person may be convicted in an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all reasonable doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question a bailiff concerning the testimony or the law, nor should you discuss the case in her presence. If any question develops during your deliberation, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted in evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have outside information, you should not mention this information to any other juror nor consider it yourself in arriving at a verdict. Our law provides that the defendant may testify on his own behalf if he elects to do so. This, however, is a privilege accorded to the defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against the defendant. You are the exclusive judges of the facts proved, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous verdict, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. And the verdict page that is attached states, we the jury find the defendant not guilty as charged in the information of unlawfully carrying a weapon, engaged in criminal activity. If that is your verdict, you will sign the top of the verdict page. Or we, the jury, find the defendant as charged in the information or we, the jury, find the defendant guilty as charged in the information of unlawfully carrying a weapon, engaged in criminal activity. And if that is your charge, your foreperson will sign on the bottom line. State, are you ready?
He's ready.
Defense, are you ready?
Ready, Your Honor.
Mr. Hubel and Mr. Crocker, is 20 minutes enough for your closing, or do you need some additional time?
20 is plenty.
I think you can get it done. Your Honor.
20? Okay. Okay, Mr. Hubel, state has the right to open and close.
State waives its right to open, reserves its right to close.
Okay. Mr. Crocker, you may proceed, and I'll be keeping time. I'll let you know at 5 minutes.
Yes. As the charge said, what we say, you not evidence. You have all the evidence you need to consider. Why am I here? I'm here to point out what I feel are the strengths or the weaknesses of the particular cases. I've never been real comfortable in closing arguments in front of juries because I almost think that it sounds like you're talking down to someone. Or maybe trying to persuade them for a bill of goods that they don't want to buy. So what I'm going to do is I'm going to just kind of line item, bullet point, go through some items and ask you to give them the type of consideration that is necessary. At the very beginning of this process, we were told, you were told through us, that we cannot give you a definition of reasonable doubt. Each individual juror must have that definition in their mind. And it's a personal definition. We do know this though, that the jury charge says it doesn't have to be an elimination of all doubt, just reasonable. So I'm going to ask you some questions about these. This is reasonable. One, not a single EMT technician, nurse, or doctor. Those people with medical qualifications testified from that stand told you anything about Mr. Bailey's condition. You know from the call logs, EMTs were there for 40 minutes or more. Who were they attending to? The only person that needed attention, Mr. Bailey. The state didn't produce a single person that said, yeah, man, when I was there, he was intoxicated. Remind you, the state's Exhibit 5 you can ask for all these exhibits, by the way. State's Exhibit 5, which is the forensic analysis of the blood, concludes Mr. Bailey was 0.142. 0.08 or above is considered intoxicated per se. The state wants you to believe that he was almost twice the legal limit. What time frame are we looking at the time that he operated a motor vehicle? Don't you think if the EMTs observed that, they would have been here to testify. The nurse, where he was released at the medical hospital or examined at the hospital, you think they'd have brought her? You think they would have brought the doctor? Didn't happen. LVN, second nurse, drew the blood. She didn't come and testify as to how intoxicated he was. Why? Isn't that what you would want to hear? Secondly, if you discount the blood, the state has a second allowable theory in which to convict a citizen by having lost normal use of the physical and or mental faculties. Now, this is somewhat confusing, but I want you to understand this. The state can say you're either 0.08 or above, or having lost mental and or physical faculties. So if you say, yeah, the blood's not right, then we gotta look at the mental and or physical faculties. That's where State Exhibit 1 is a really, really good piece of evidence. It's live, it's on the scene. It's there, it's real time. Ask yourself, does he appear to be twice the legal limit? Does he appear to have lost his mental and or physical faculties? No. The officers are asking him, hey man, what happened here? I was coming around, car came out, I hit it. They disagreed with his interpretation, but he was telling them exactly what happened. Hey, you got insurance? Yeah, let me call them. Who calls their insurance company at 12 at night? He's using the phone. He's trying to get in touch with them for the officer. You got a pistol? You got any firearms? Yeah, on the left-hand side. Okay. Oriented as to time and place. Both officers testified as to that. Do you recall? Do you think he lost his physical and or mental faculties? And I want you to understand we have another issue, and I'm sure it doesn't fall short on you. And that this man said I was going between 35 and 40 miles an hour. His own words. And the car flew up from me. The officer said he was probably ejected. I believe he was. You get ejected at 35 to 40 miles an hour after hitting a car, you hit the pavement. Did you see a helmet on him? No. He's lucky that he's here. Broke his nose, blood all over him. You think he might be in a little bit of shock? You might think he might be in a little bit of panic. But they're saying, oh, those are signs of intoxication. Red, bloodshot eyes, a little bit of agitation. What's he keep saying over and over? I need to check my bike. I need to check my bike. He's worried about his bike. That's his sole mode of transportation. How would you act if you got ejected 30 to 40 miles an hour onto the pavement on your face? Now, the EMTs went in and checked him out and said, you sure, buddy? You sure you don't want to go to the hospital? I'm fine. Typical man, I'm fine. FST, you heard it, 2 days, field sobriety testing. Officer Menard, I'm sure she's a really nice lady. I know I didn't make any friends. Just don't think she was the right officer for that call that night. She was getting constant instruction from a supervisor after being on her own on the street by her own testimony for 7 months. She didn't know when to perform the FSTs. She tried it at the scene. They said start over. They tried to explain it as a safety issue. We talked about the flashing lights. Yeah, you should know those flashing lights. She was all over the board. The fact of the matter is, from the time she arrived to the time that she dropped him off at the jail, Her fingerprints are all over this thing where she did it wrong time and time and time again. For God's sake, she filled out an affidavit to a judge that wasn't even correct. Not just one typo. Remember, oh, that was a typo. One item after another item after another item. Sergeant Guerrero said, well, I just assist her. Did you have any part in writing the warrant? No, you're right. He was there on the scene trying to tell her, fill this paperwork out, this is what you saw, this is what happened. Oh, I forgot something at home. Got to be in her apartment. She's going to get her cell phone. I never understood that. Very peculiar indeed, but nonetheless, it shows a level of familiarity between the two officers that frankly is a little disturbing in that he is still spoon feeding her on the street 7 months later. U.S. citizens deserve better policing than that. Mr. Bailey deserves better policing than that. Where do these files come from, ma'am? I don't know. They just magically show up in the car. Do they ever get rotated out? Well, I'm sure they do. You're gonna have to ask the evidence technician or whoever puts those in the car. Okay. You heard the testimony. You do not keep these files in anything that is not room temperature. The trunk of a car in August in Southeast Texas. You're allowed to use reasonable inferences. How hot you think that trunk is? Day in, day out, week in, week out, month on, month out. You see, the integrity of the testing starts with that. I don't believe that she physically could make a determination with the FSTs. We know this. An officer asked her, 1055, code 4, is he intoxicated? The response, I don't know. You don't know the guy's 2 times over? State's gonna say, well, she needed to investigate further. I submit to you, you know when a man's 2 times over. You don't need further investigation. But then we go to, well, we took him to a safer place, the yogis. Watch the video. 2 times over? What did he do? He did an unfamiliar exercise that he never practiced, that the officer said, yeah, reluctantly, she said, yeah, you get better with practice. How many times have you done it, man? Oh, I have no idea. You practice it on over and over and over at the department, and presumably before any arrest, they're supposed to demonstrate to the citizen they're about to arrest him to do it. And understand that these are subjective. It's the officer's opinion. You heard Officer Guerrero say that. Her supervising officer, what's officer's opinion? Officer Guerrero said, yeah, I didn't see all those tests. Tabor, well, it's nothing to do with this. What he said, I just worked the record. That's it. So the totality of all this is, do you think that there is a reasonable inference that there is alternate experience? 9 days the blood samples sat after being collected in the Groves Police Department evidence locker. 9 days. I know we have someone here in the medical field. Do you put blood 9 days, room temperature, and expect it to have a legitimate result? Officer Menard cannot tell you what she put the sample in the evidence locker, where it went. Oh, it's refrigerator or not. State doesn't say, yeah, we got it refrigerated. What the evidence technician said was, when I get it, I let it sit out so I can test it, and then I refrigerate it. We have no idea how many times it's been refrigerated, not refrigerated, thawed, unthawed. I don't know if it's frozen, I doubt it. The fact of the matter is, we don't have that evidence that is derived from there to give you the information that is needed to say, yeah, that's all done on the hub. Do I think there's nefarious intent? No, I just think it's negligence. Do I think Officer Menard set out that day and say, I'm gonna go get me an innocent guy? No. I think once the wheels in motion got put into motion by that first call, and someone suggested there was an intoxicated person, you don't back off. You just keep going, you keep going, you keep going. If Mr. Bailey had lost the normal use of his physical and or mental faculties, why in the world would an officer instruct him on a divided attention test? Remember, two parts, the instructional phase and the performance phase. Give him the instructional phase and say, do you understand? Yes. Surely, the officer thought he understood. He answered in the affirmative. Would you, as an officer, if you thought someone had lost their mental and or physical faculties, give them a complex set of instructions, so ask that they perform them, and when they don't, say, gotcha. Never thought she had. Not how this works, folks. It's not how this works. Was he oriented as to time and place? Yeah.
Mr. Crocker, you have 5 minutes.
Did he have the odor of alcohol about him? Not according to the affidavit search warrant when I pointed out, oh, I lost my smell during COVID. Other officers said, well, I didn't get close enough. And then the other officer said, what? I think it did, but I'm not really sure. Ladies and gentlemen, you need more to convict a citizen than this. Mr. Bailey deserves more, and your community deserves more than this type of police investigation. Poor training, poor performance, terrible evidence handling. That in and of itself should be plenty for you to render a verdict of not. Thank you.
Mr. Hilbert, you may proceed.
Thank you.
I'll let you know in 5 minutes. You can start.
I want to first thank you all for your time this week. Your patience and attention in this matter is incredibly important to this process. So, as we said at the beginning of this, this is a consolidated case, and these cases are both a driving while intoxicated case and an unlawful carrying of a weapon case. Now, in Mr. Crocker's closing, he spoke about witnesses that weren't called. That's something that's outside the evidence that has been offered and admitted in the testimony. That's something that it should not be considered in this matter. So the defendant on the scene was cleared by the EMTs and subsequently cleared by the hospital. And Mr. Carter is making statements that he's oriented as to time and place, but talking about how the SSTs are faulty because he was not able to understand it. So these arguments are in conflict with each other. And ultimately, in regards to the issue with Officer Menard's warrant, the warrant still contained the correct information necessary for the necessary for the board warrant to be effective. The, the, the question as to whether the question to Officer Menard as to whether the defendant was intoxicated from Officer Tabor, the 1055 statement that Mr. Gardner was talking about was made prior to the officer's investigation and subsequent testing of the defendant. He, and as well during the SST, she clearly and thoroughly instructed the defendant as well as demonstrated the test before administering them. And it is, the SSTs are suggested, but what isn't suggested in this case is that the defendant, Matthew Joseph Bailey, was intoxicated while operating a motor vehicle and got into an accident with another vehicle that was slowly turning into the driveway. So with that in mind, I'm going to go element by element with these two charges and point to you the evidence by which the state has proven this case beyond reasonable doubt. So first, I will take three elements at one time. Jefferson County, Texas, the defendant Michael Joseph Bailey, on or about August 29th, 2021. So the officer's testimony is in this accident took place at the 2000 block of Main Avenue in Groves, Texas, which was in Jefferson County, Texas. This is also shown in States 1 and States 4, which are the videos of Officer Menard and Officer Tabor's body cams. All the officers also identified the defendant in court. This is in testimony, as well as in those two videos. And the date on or about August 29th, 2021 was also testified to by all the officers on the stand. Operation of a motor vehicle. The defendant's own statements in the body cam, as well as the officer's testimony regarding that, are show admissions that he was operating the motorcycle, which is a motor vehicle, as testified to by the officers, when he got into the accident on Main Avenue. In the element of in a public place, this is also satisfied by officers' testimony and the video in States 1 and 4. They testified that they rose in public place and that this was in fact on a road on Main Avenue. So that leaves intoxication. The defendant was intoxicated at the time he was operating the motor vehicle. So there are three bases by which intoxication can be shown. Loss of mental or physical faculties is 1 and 2, and the third one is having a blood alcohol concentration of 0.08 or more. So the officer's testimony showed from Menard and from Guerrero identified that the defendant had slurred speech on the scene and exhibited red glassy eyes. Sergeant Guerrero, in testimony while I was questioning him, said that it was in his report that he smelled alcohol in his breath at the scene. The SSTs we went over extensively with Officer Menard. She listed the clues that they exhibited and what was required in order to make an indication of intoxication. So the defendant's signs of intoxication that he exhibited at the scene, as well as on the test, and go to show a lack of mental and physical faculties. You can see that in States 1 by reviewing the video, and you can also ask for excerpts of testimony specifically about the signs of intoxication if you so choose. Now, on to the third basis of the classification, the blood. That States Exhibit 3 and States Exhibit 5. The States Exhibit 3 is the blood kit, the blood tubes themselves. And States Exhibit 5 is the test results from the testing that was conducted by the individual from the Jefferson County Regional Crime Lab, Emily Altamirano. At the time of testing, the defendant had a blood alcohol concentration of 0.142, which is far above the legal limit of 0.0. Now, the defense brought an expert to talk about certain issues with the blood, but the defense's expert had no personal knowledge of that blood, did not test the blood herself, and in fact, had not even seen.
Yeah, approach real quick.
Okay.
May I continue, Ron?
Yes, let me start the clock back. You may continue.
So, as I was saying, the defense's witness on the stand said that she had no personal knowledge of the blood, and that she had not personally tested the blood herself, and in fact, had not even looked inside the green tab tubes before this date or even on this date. So she cannot speak to what has happened with the particular vials or the samples with them. With all that evidence in mind, I would ask that you take into account the totality of the evidence in this case and find the defendant Michael Joseph Bailey in Jefferson County on the date of August 29th, 2021, operated a motor vehicle in a public place while intoxicated. And they can render the true verdict of guilty and like this. Moving to the UCW, one of the major elements of the UCW is the defendant engaged in criminal activity, a DWI, which is an offense other than class C misdemeanor. The elements that I discussed with you before are the elements of DWI. So those things that we've discussed previously would go to proving that element. The UCW also requires that it take place in Jefferson County, Texas, by the defendant Michael Joseph Bailey on or about the date of August 29th, 2021. We previously discussed that the officer's testimony, as well as the videos in states 1 and 4, that go to prove all those elements beyond a reasonable doubt. Now, on to the element of intentionally and knowingly carrying on or about this person a handgun. In states 1, as well as the officer's testimony, the defendant's own admissions are on video saying that he had a firearm on or about his person in the left saddlebag of his motorcycle. And then you can see in states 1, Sergeant Guerrero approaching and securing that same firearm. You also can view states 2 yourself, states 2 being the actual firearm involved in the case. Now, the final element for UCW is in a motor vehicle in the defendant's control, We've already established, via officer testimony that the motorcycle was a motor vehicle and the defendant in the operation of the motor vehicle, and places it under his control in the video as well. So. With that in mind, I urge you to review all the exhibits and any testimony that you need in order to make a true verdict in this case. And I ask that you make a true verdict for the guilty in these cases, both the DWI and the UCW. Thank you.
At this time, ladies and gentlemen of the jury, the evidence, the court's charge, and the closing arguments are before you. I'm going to hand the charges to the bailiff to get together with the verdict forms. They will be left with your jury room during your deliberation. Once all members of your jury are present and assembled in the jury room, the case will be formally submitted to you and you may begin your deliberations. At this time, I think we noticed, I inform you that on a criminal jury case, you have 6 jurors. If you notice, there's 7 of you. One person is an alternate. The alternate is not allowed to go into the jury room, but the alternate must be available just in case something happens to one of the other jurors, and the alternate will then go in. The alternate in this case is Gerald Dwayne Bass. Mr. Bass is here? Okay. So everyone, exception of Mr. Bass, please follow the bailiff into the jury room. Mr. Bass. Mr. Bass, you can remain in the courtroom, or if you want to sit out in the hallway, you just have to be available. Okay. At this time, the court will be in recess.